forget to like and subscribe.
And hit the notification bell
so we can go to college and get more knowledge.
Ether is one of the most popular digital assets and powers the Ethereum blockchain. Back in 2018, then SEC Corporation Finance Director Bill Hinman stated that he believed Ether was not a security. Last month, CFTC Chair Benham expressed his view that Ether is a commodity. The State Attorney General of New York asserted in a court filing last month that Ether is a security. Clearly, an asset cannot be both a commodity and a security. Do you agree?
Actually, all securities are commodity under the Commodity and Exchange Act. It's that we are excluded commodities, but I would agree that a security cannot be also an excluded commodity and an included commodity. I'm sorry, Chair, just to talk about the Commodity Exchange Act more precisely.
Okay, so do you recognize, how would you categorize Ether then?
Look, I think that the general sweep of what Congress did, not just in the 30s, but as amended.
I'm asking you, sitting in your chair now, to make an assessment under the laws as exist. Is Ether a commodity or a security?
Without speaking to anyone.
I know you've repeatedly said you're not going to speak to one, except you've spoken to one, Bitcoin. So I'm asking you to speak to a second one, the second largest market cap here.
And speaking to the tokens, there's 10 to 12,000. If there's a group of entrepreneurs in the
asking
middle,
about one.
The public is anticipating a profit based on the...
I'm asking you a specific question, Chair Gensler. I said this in private. This should be no shock to you. I'm asking this question. Is Ether a commodity or a security?
And again, it depends on the facts and the law, and if there's a group of individuals...
I'm asking you about the facts and the law sitting in your seat and the judgment you are making.
And so, Mr. Chair, I think you would not want me to prejudge because I'm also...
But you have prejudged on this. You've taken 50 enforcement actions. We're finding out as we go, as you file suit, as people get Wells notices on what is a security in your view, in your agency's view. I'm asking you a very simple question about the second largest digital asset. What is your view?
And my view is if there's a group of individuals in the middle that the public is anticipating...
All right, so let me just ask a second question then. Do you think it serves the market for an object to be viewed by the commodities regulator as a commodity and the securities regulator to be viewed as a security? Do you think that provides safety and soundness for the product? Do you think it provides consumer protection? Do you think it serves the value of innovation? I think no should be a very simple answer for you here.
I think
that uncertainty is bad, is it not?
And I think that Congress has said that there's one agency, the Securities and Exchange Commission, under this committee.
And you won't answer my question, and you're the head of that agency. So give me a break. Come on.
Section 956 of Dodd-Frank requires the SEC and several other agencies to write rules to ban incentive-based executive compensation that encourages inappropriate risk-taking. It has been almost 12 years, since we passed Dodd-Frank, and the SEC, like other required agencies, still hasn't finalized this rule. So what step has the SEC taken under your leadership to finalize this important rule?
We have initiated discussions with the other 5 agencies. We have to work with the bank regulators and the Federal Home Loan, FHFA, to do this. But I'm committed to get this done. We have to do it in coordination with the bank regulators.
When? Another 12 years? Sir, it has been publicly reported that Greg Becker, the disgraced CEO of Silicon Valley Bank, sold $3.5 million of Silicon stock less than 2 weeks before the bank's collapse, raising questions about whether he ran afoul of insider trading laws. What actions has the SEC taken to investigate stock trading by bank executives leading up to the bank's collapse?
If I could step away from any one circumstance and say it's against the law to trade on material non-public information. That's whether you're at a company or whether you're in just a private citizen, that's against the law, and we take that very seriously.
All right. Okay, so two.
That companies make are public filings. They already are public. It already is known. And once again, I find you trying to hide behind things for either a lack of willingness to be candor about it, or you're trying to obfuscate your oath of office, which was well and faithfully. This committee is not happy with that attitude or performance. I was told by you, after we'd had numerous discussions with your staff, about a company that had a capital formation issue with millions of dollars at risk at the last minute based upon their public filings, that you would not respond at all or even discuss the matter with the company to try and alleviate a problem for the average number of days that it would take your agency to respond. In other words, the agency had to respond. You were simply a placeholder. You have no real responsibility. You have your own views, not the views of the management. Almost every
right, so I want to click that one off. I want
on current law, of those 130 cases, those 130 enforcement actions, how many have you won? How many has the SEC prevailed on?
Many of them are settlements, but those that we've taken to court, we've won on the Howey analyses, these token issues, 6 or 8 times. We've won on other matters in front of the courts as well. So we've been quite successful throughout.
All right, so you look at that clip.
Of FTX, did you have any concerns with the company or question if they were breaking any securities laws or harming investors?
I think, if I might, I have had, since I've been in this job, a general concern about the field, and as expressed here today, about the non-compliance of this commingling of these various functions, and that they should come into compliance by separating exchange from broker-dealer, from what you might call a hedge fund function and other functions.
So with those concerns, did you direct your staff to look into FTX?
I want to stay at a little bit higher level, but I directed the staff to look into the crypto intermediaries and a wide range of crypto intermediaries. Yes, sir. Anything we do in our examination function, our investigative function, we protect that information and hold it confidential because it's important for the integrity of any investigation, but also for people's privacy. And often we find that we close investigations without bringing action. So there's a time-tested reason that you, of course, would want us to keep things confidential. So we only make them public when and if we either settle or bring charges.
Sad to hear that.
Banks cannot offer digital asset custody services at scale without significant balance sheet implications. If banks cannot provide digital asset custody services at scale, they simply will not offer those services, which could lead to market participants not having bank-grade custody solutions to pick from and will turn to offshore solutions, like in the Bahamas, diminishing American competitiveness and compromising investor protection. Chairman Gensler, has it occurred to you the irony that at the same time you pursued SAB 121, which has effectively precluded highly regulated banks from offering customers the safety and security of segregated digital asset custody services, not a single one of the 4,500 employees under your supervision at the SEC noticed that FTX was allowed to commingle customer funds, allowed FTX to trade, settle, custody, lend, and borrow digital assets without institutional-grade custody?
Is it more difficult now for the digital asset industry to access financial products and services in the United States than it was, say, 2 years ago?
Sir, I'm not running one of those businesses. If they came into compliance, I think
Reclaiming my time. The answer, sir, is yes. Do you think you and the SEC have had a role to play in that?
I think we have a role to protect the American investor and the capital markets and the.
Reclaiming my time, sir. You have played an obvious role in that. During your tenure at the SEC, how many rules has the SEC finalized that actually accommodate the existing regulatory framework and are specifically to the digital asset industry so the crypto market can come into compliance?
It's our rule books that are on the books for years, so we have not finalized any new rule specifically with regard to crypto. We've proposed some things in best execution. We've also...
Sir, reclaiming my time, the answer is 0. And how many enforcement actions has the SEC levied against digital asset companies during your tenure, sir?
I think it's probably 40 or 50.
The answer, sir, is about 55. My understanding is that the biggest crypto failure in history is probably FTX at $9 billion. Were you the chairman of the SEC when FTX collapsed?
Yes.
And how many times did you meet with FTX prior to their collapse?
I think my public record shows 2.
You met it with FTX at least twice. And arguably, the second biggest crypto failure in history was Terra Luna. Who was the chairman of the SEC when Terra Luna collapsed, sir?
We had brought...
You were, sir. Reclaiming my time, you were. There are 5 members on the commission. Do you believe your speeches and interviews are to serve as the official position of the SEC?
I can only speak for myself when I'm speaking.
Again, sir, in a statement on the SEC website, you are quoted saying, the Kraken staking as a service enforcement action should make clear to the marketplace that staking as a service providers must register. But again, you haven't provided any rules for how that can be done. I must remind you, your public statements are not regulations. It's not responsible to expect the American people to assume your statements are a substitute for rules. Do you agree with this statement regarding the digital asset industry? The SEC needs additional congressional authorities to prevent transactions, products, and platforms from falling between the regulatory cracks.
I think that it's a largely non-compliant field. And
sir, again, I asked you to comply with my questions, and I'm asking you if you agree with that quote. And I'm going to tell you, I'm quoting you from an August 3rd, 2021 article where you, and I believe you told Congressman Hill earlier that you need congressional authority to regulate stablecoins, and stablecoins happen to be a significant percentage of the crypto market. So the question is, when were you telling the truth? To Mr. Hill or to me? You've got to start answering these questions in a more transparent manner, sir. Does it concern you, by the way, that your approach to the digital asset industry is actually driving this industry out of the United States?
We're trying to drive it to compliance, and if they're not complying with the laws, then they shouldn't be offering their products.
Reclaiming my time. Madam Chair, I would like to enter into the record this Wall Street Journal article from April 14th, 2023, detailing China's ploy to open its banking system to crypto firms in an effort to seize an opportunity created by our hostile regulatory environment, which, Mr. Chair, you're a big part of.
Without objection.
Chair Gensler, FTX was domiciled abroad and so is Binance, yet American consumers still had access to both. You can't really think that pushing this industry abroad is going to protect American consumers when it hasn't several times in the past on your watch. You say the crypto market is rife with non-compliance. However, existing SEC rules make no sense for blockchain-based companies, and following them would actually kill these businesses. Your regulatory style lacks flexibility and nuance, and as a result, you've been an incompetent cop on the beat, doing nothing to protect everyday Americans and pushing American firms into the hands of the CCP. Your intention to work against SEC mission and put American investors in harm's way has been made very apparent, sir. It's been a year and a half since you've appeared before this committee. You need to answer to Congress about the issues that you've had with the SEC staff union, the work environment you've cultivated at the SEC that's led to hemorrhaging of senior staff, the intellectual inconsistency of your regulatory treatment towards Bitcoin spot ETFs, and your politicization of capital formation opportunities through your treatment of certain SPACs. And that's just to name a few.
Man, I tell you, Emmer just got heated there.
In advance of today's hearing, did you coordinate acceptable responses with Senator Elizabeth Warren?
No, I'm speaking on my own behalf.
Did you coordinate with Democratic staff? And I ask because it happened before, and I want to be clear whether you operate of your own accord or whether there's some sort of coordinated approach to the damage that you're inflicting on America's capital markets.
I'm here as sitting in my role as chair of the agency, but I speak and I get remarkable support by SEC staff.
All right, well, I have a few quick questions where a yes or no answer will suffice. Chairman Gensler, part of the SEC's mission is to protect investors. Does the SEC review pre-IPO documents?
I think you said pre-IPO documents. You're supposed to, if you're going to take a company public, the staff of the SEC does review those to see that they're in compliance.
Correct. Is Coinbase a publicly traded company?
I'm sorry?
Is Coinbase publicly traded?
Yes.
All right, so the SEC allowed pension funds and retail investors to invest in a company, Coinbase, that you apparently, from prior remarks, believe was engaging in illegal activity. All of their activities were laid out in their public filings in the S1 prior to the IPO. You did say that you believe Coinbase is selling unregistered securities, correct?
Again, I'm not going to speak to anyone.
No, but you said that they're selling unregistered securities. This is your public comments.
I think, with all respect, I look forward to you finding that because I'm trying to be very careful. I'm not speaking
we'll help
about
refresh
any
your memory.
one company.
In the Kim Kardashian settlement, the SEC stated that Ethereum Max is a security. She reached a settlement for promoting an unregistered security. The unregistered security is Ethereum Max. Have you charged the issuers of Ethereum Max for offering an unregistered security?
We reached a settlement with a celebrity, Ms. Kardashian.
Yeah, but not, she just promoted it. She doesn't operate Ethereum Max. Have you said that Ethereum Max is an unregistered security to the people that offer it?
We did in that settlement, yes, sir.
Okay, it's still trading. What about Ethereum? Is Ethereum now a security?
We had this
I heard your exchange. They've been in place since 2015. You say in your statements that there's clarity in the market and the rules are clear. Just come on in. You can't even answer the question. Do you say XRP is a security?
Well, we're in court and active discussions and litigation on that.
You're in litigation because you do say it's a security. As you know, let's move on a little bit. As you know, qualified custodian banks would effectively be unable to provide crypto asset related custody as a result of punitive capital impact under accounting provisions in Staff Accounting Bulletin 121. Do you agree that the bulletin should be amended?
I think that the staff addressed an accounting issue and appropriately saw that crypto assets held in custody today are not segregated or not bankruptcy remote in bankruptcy and should be appropriately put on public company financials.
I wish I had time to go into the ESG rule and everything else, but Chairman Gensler, your record of failures to protect investors and abuses of power make it clear that we need to restructure the Securities and Exchange Commission. The failures are many, but let me cite some of the abuses. You average more than 2 rules proposals a month. You provide inappropriately short comment periods. You have unworkable and unlawful ESG disclosure mandates on the market. You have essentially a Hotel California rule for crypto where you can check in anytime you like, but you can never leave. You have endless discovery with no resolution and no clarity for the captives in the market. You have unworkable proposals for overhauling equity market structure, a de facto ban on crypto through proposed custody rule. You have high staff turnover, unhappy people leaving your office, and unhappy companies and capital leaving our country. To correct a long series of abuses, I'm introducing legislation that removes the chairman of the Securities and Exchange Commission and replaces the role with an executive director that reports to the board where all authority would reside. Former chairs of the SEC will be ineligible under my proposed bill. And this isn't just my take. It resonates across the political spectrum. The American people want democratic access to capital, retail investor participation. You can't just exclude retail investors from markets and claim it's for their own good. Our markets need to function and flourish, and I yield back.
All right, I think,
Knowledge.